Hello everyone, I, Sunita Tripathi, am Assistant Professor at the General Global Law School, where I teach courses related to intellectual property law. Today we shall discuss a module titled Fundamental Concepts Pertaining to the Law of Industrial Designs. The aim of this course is to understand why do we need to protect designs in the first place, and if at all they are protected, how are they defined by the Indian law. We will traverse the legislative history along with the definitions propounded by the courts and discuss important case laws to understand this interesting species of intellectual property. The learning objectives include case law analysis, definitions and interpretation of important terms which define what a design is as opposed to what is copyrightable subject matter, and of course finally leave you with some thought-provoking questions to answer what kind of designs are protectable in India and abroad. So let's begin. The legislative history of the Indian Act of Design Law turns all the way back to 1872. The Patents and Designs Protection Act of 1872 was the first design legislation enacted in India. Thereon, we had the Indian Patents and Designs Act of 1911, and finally we have the new designs law, which is known as the Design Act of 2000, as well as the design rules of 2001. The design wing of the Patent Office, Kolkata, is entrusted to administer the provisions under the Design Act of 2000. So that is how Design Act is regulated in India. So why protect designs? All the shapes, configurations, patterns, ornamentations, etc. are the output of human intellectual effort. And so this species of intellectual property law looks to reward those creators who create newer shapes, patterns, configurations, and add a new aesthetic value to existing articles. Much thought, time and expense may have been incurred in finding a design which could increase the sales and marketability of the product. Therefore, this space of intellectual property confers an exclusive right for a maximum period of 15 years on the proprietor of a design. The term of protection of an industrial design is defined under Section 11 of the Designs Act, which lays down that 10 years from the date of registration, which can be renewed for a period of 5 years, leads to a term of protection of any design in India. Therefore, maximum period for protection of design right is 15 years. However, the right under Design Act 2000 is known as copyright. The exclusive right to apply a design to any article in any class in which the design is registered is known as a copyright under the Designs Act of 2000. And the criteria for registration of such designs qualifies only when a design is new or original, it has not been disclosed to the public, and is significantly distinguishable from known designs or combinations of known designs, and it does not comprise of any scandalous or obscene matter. Its use would not be contrary to public order or morality. One image in this particular slide involves a new sort of designed bookshelf. An ordinary bookshelf would have only levels of shelves wherein you can house your books. However, this one is made of wrought iron and has complex patterns which makes it a designer bookshelf. Therefore, whoever has come out with an ingenious way of ornamentation and creating a new visual effect to an existing bookshelf leads to a person entitled to a design right if he or she so desires to register it. The object of a statutory design law is to ensure that creators of profitable designs are protected against unlawful copying of the designs. The Act seeks to actually protect visual elements of an article rather than the functionality of an article, which would fall into the realm of patent law. Patent law has a utility concept, and therefore any article which is so designed to increase the utility of an article would actually constitute a patentable subject matter, as opposed to one which is aesthetically and more beautifully presented and so protected under the design law. In India, like I mentioned, the right conferred upon a registered design is termed by the Act as a copyright. So the law of design focuses on the aesthetic feature of an article derived from its visual appearance. And the subject matter which is protected by law of design is the application of the design to the article. Therefore, a design or a right of a registered proprietor of a design would mean the exclusive right to apply the design to an article in any class in which the design is registered. The exclusive right to import for the purposes of sale any article belonging to the class in which the design is registered and having applied to it that design. And so the exclusive right to publish or expose or cause to be published or exposed by an article in any class of goods in which the design is registered to which the design is applied. The image here in this slide is that of an armchair. It's a designer armchair having a canopy of sorts of an appearance. And therein, in the next slide, there are sets of other 4 new armchairs. Now, if there is a design week wherein designers who actually invest the intellectual effort to create a new visual effect of what an ordinary chair looks like, and therefore increases its marketability. It attracts and appeals to the eye of a discerning consumer who wants to buy a chair which looks different and not just an ordinary one. So 2 characteristics of design law are visual aspects and the articles to which such design is applied. The visual aspect has an important impact on the types of subject matter protected as registered designs. The articles would involve the protection given only to the design which is applied to articles. This means the garden designs, urban planning and architectural designs, etc. have been excluded from the scope of design protection. Let's delve deeper into the definition of design. Section 2D defines the term design to mean only the features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article, whether in 2-dimensional or 3-dimensional or in both forms, by any industrial process or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeals to and are judged solely by the eye, but does not include mere mechanical device, and does not include any trademark as or any property mark as defined in section 479 of the Indian Penal Code, and importantly, any artistic work as defined in clause C of section 2 of the Copyright Act. Some of the important terms of this definition needs to be understood. Let's begin with the term article. The design must be applicable to an article of manufacture. Thus, it means that designs for buildings and structures will not be registrable. Secondly, made and sold separately. In deciding whether an article was made and sold separately, it has been understood that it is irrelevant that the part were in fact manufactured, stocked and retailed separately. However, what is important is, since the visual effect needs to be applied to an article, this application has to be done in a way which can be removed from the article and is so not intrinsic to add a functional value to such an article. And therefore, design goes on to protect only the ornamentation or the visual effect. Appeal to and judged solely by the eye. As already mentioned, the design must be judged not by an objective measurement or scientific evidence, but by visual comparison of previously existing shape, configuration, pattern or ornaments, and thereby any added value which adds to the appeal of the article and therefore making it more commercially exploitable, and therefore consumers will find it more attractive to then go on to actually purchase it, is what is protected under design. So now simplifying the design, design features must be capable of having a separate existence altogether from the article. There are 3 main components: the visual character and the appeal to the eye and non-functionality, the application by any industrial process or means, and finally the exclusion of trademarks and artistic works. And that will help you understand what is defined as an industrial design. The prerequisite for industrial designs is the aspect of originality and novelty. So a design to be registrable should be new or original. New meaning the shape or pattern is completely new and therefore created for the first time and was unknown to the public before such time. So in that sense, it has to have a novel aspect, a design made that no one has seen before. And going back to our previous slides where we explained about different forms of armchairs, each armchair is distinct in itself, but functionally they are armchairs. However, when you look at it from a perception of a consumer looking to buy a preferred armchair, you will buy an armchair which appeals to your eye. And that appealing aspect is what is the contribution of industrial design. Secondly, the prerequisite of having originality. A new application of an existing or known design to a new article is what is held to be original. The Calcutta High Court judgment of 1919 is one which is cited in several Indian textbooks to explain what is meant by prerequisite of design protection. The matter is Gameter versus Controller of Patents and Designs, and the court upheld the claim of novelty or originality for the registered design of a metal wristband for watches, although gold bracelet of the same kind was used as jewelry for several years. The court opined that although the shape of the band was not new or original, but its application to the watch was for a purpose, and this design could be said to be original. So the important aspect is a visual effect when applied to an article in a novel way can satisfy the prerequisite for industrial design protection. The test of novelty as a prerequisite for a design protection has been upheld in the matter of Hello Mineral Water Private Limited versus Thermo King California Pure. The plaintiff claimed that he had registered a design dated 13/5/96 and has sold goods up to May 97 worth 2 crores of rupees and built up goodwill in respect of water coolers. The defendant's design for its water coolers is found to be an imitation and therefore infringing the plaintiff's copyright by using the same design in respect of the same articles, that is water coolers. The defendant claims that there is no novelty in the plaintiff's design, for it was already known and was being used in the market both in India and abroad. However, the courts reiterated that once a design is registered, it is the registered proprietor who can insist that anyone committing piracy should be restrained from doing so for the purpose of the Design Act, and to protect a novelty in the design is to be applied to a particular article to be marketed commercially. So in this case, the article being similar, the design being an imitation, the consumer overlap leads to, in a sense, establishing the case of infringement or design piracy. The novelty, as defined by the court in this case, involves the presence of some element or new position of an old element in combination different from anything found in any prior disclosure or structure. So the different shapes, colors may be used, and the court went on to suggest that this will advance industries and keep high level of competitive progress if the same manufacturers had distinctive designs to then on create aesthetic value and appeal to their respective consumers. While the defendants may use the cylindrical shape of his water coolers, he would use different color combinations, at least of different shades, and place the cup holder in a place which is different from that of the plaintiff, so as to allow the consumer to make an informed choice that the two water coolers are not really coming from the same source. So using holder branded names indicates its names at different place rather than the place as shown by the plaintiff would go on to show good faith on the part of the defendant in the matter. So thereon we have established what is the prerequisite or a test for design protection, the issues of originality and novelty. However, what is excluded subject matter will entail methods or principles of construction. As mentioned, buildings would not constitute designs. So buildings are architectural forms, landscaping or garden designs. These are not what is protectable under industrial designs. Features dictated solely by function. Functionality is an aspect of patent subject and not of industrial design. A mechanical device would also constitute within the realms of patentable subject matter. A trademark, property mark or an artistic work would definitely be protectable under the species of trademark law or copyright law and not designs. And finally, an immoral design or designs contrary to public order. Let's understand some rationale behind excluding certain subject matter from the protection of industrial design, and beginning with methods or principles of construction, and the example I gave was that of buildings. So methods of construction as an exclusion ensures that protection is granted to the appearances of articles rather than to the methods or principles of construction by which an article is manufactured. Therefore, the exclusion draws the line between patent law, which protects inventions, and design law, which protects appearances. The next factor which leads to exclusion of subject matter is features dictated solely by function. So a particular shape is dictated solely by function if its relevant features are brought about by or attribute only to the function which the article in that shape is to perform, even if the same function could be performed by an article of a different shape, it would lead to non-protection. The rule which is followed in this case is known as an every feature rule. A design is unregisterable only if every feature of the design is dictated by function. What it essentially means is, if a design is partly functional, it may still be registerable. The overall design has to be looked in order to ascertain that every feature of that design has no necessary relation to the function. Where a design is made up of a number of different features and some of those features are dictated by function, so long as some of the remaining design features are not determined by function, the design will not fall within the scope of the exclusion. A good example worth thinking about is the number of toothbrushes in market. They are designed separately. Some of them have zigzag bristles, some of them have separate arrangements. If those arrangements lead to additive value or functionality of such an article, then that article falls outside the scope of design protection. However, if there is a mere designer handle to a toothbrush, enabling no such extra function of having increased its functionality, such aesthetic or appearance value will be protected under design law. Functional designs. Now this is a case of Escorts Constructions Equipment Limited versus Action Construction Limited, 1999, PTC 36 of Delhi, where the Delhi High Court had the occasion to interpret this clause and opined that the expression design does not include a method or a principle of construction of features or shape or configuration which are dictated solely by function, which the article to be made in that shape or configuration has to perform. So according to the court, the definition made it amply clear that the primary object of the act was to protect aesthetic shape and not function or functional shape. And so the grounds of non-registrability of the designs would be if a design is not new or original, or there has been a prior disclosure and so the public knows about such a design from before, if it is non-distinguishable from known designs and is scandalous or obscene, then in that case it is excluded. What do you mean by not new or original can be understood that the primary requirement is that the design must be new in respect of the class of the article to which it has been applied. The novelty or originality is judged on the basis of expert evidence, which means that only an expert who is well versed with the design or the common trade practices and usages in the class of goods to which this design is applied would be the one entitled to pass a verdict on the novelty and originality. The element of prior disclosure essentially means that when a design is not previously published in India, then the publication would actually require that the design is available to the public or it has been shown or disclosed to anyone who is not bound to keep it secret. Then such design will not be considered registrable. Such publication can be made in any prior document or even prior use. Therefore, in a sense, publication would mean the opposite of being kept secret as held by the Delhi High Court in the matter of Vimco Limited Bombay versus Meena Match Industries. The disclosure, even to one person, is sufficient to constitute publication. Prior disclosure is a very strong element for non-registrability of industrial designs. Section 4 goes on to further give elements of non-distinguishable from known designs. In case of a combination of previously known designs, it will qualify as a registrable only if such combination results in a new visual appeal. Therefore, it has to be distinguishable from known designs or combinations of known designs or comprise. And finally, a scandalous or an obscene design is not protectable under Indian law. That would mean anything which hurts the moral sentiments of the nation or the people of India will not be protected under design law, no matter how aesthetic. Let's understand the requirements for cancellation of registered designs. While we have understood what is not registrable, what leads to revocation or cancellation after the grant of a design right. The Act does not provide for advertisement of the application, for registration or for the opposition to the registration, and that's a new kind of a provision because most of the intellectual property laws have an objection clause prior to grant. However, any interested person can file a petition to the controller seeking the cancellation of a registered design. This application for cancellation is admissible only on the following grounds: that the design has been previously registered in India, that is, it has already been used priorly by someone else, that the design has been published in India or any other country prior to the date of registration. This enhances the bar for novelty. The novelty for industrial design has to be worldwide, and that the design is not new or original design, and if it is, not registrable under the Act as per Section 4. In the matter of Western Engineering Company and Paul Engineering, which is a 1968 Calcutta High Court judgment, the registered design for a cycle lock was cancelled due to lack of novelty or originality, and also for prior publication. It's one of those rare cases when a granted industrial design is cancelled out for not adhering to the statutory norms. There is a stark understanding while we define section 2D to be what constitutes design. The one aspect which is involved is that artistic nature, which is protected by copyright law, cannot be protected under design law. So there may be certain designs which can anyway qualify for registration both under the Design Act and Copyright Act, and this industrial design or product design are covered by Designs Act of 2000. Therefore, if an original artistic work has been registered as a design under the Design Act, then the same subject matter cannot enjoy a coterminous protection under the Copyright Act. However, if a design qualifies for registration under the Designs Act but has not been so registered, then the exclusive right will subsist under the Copyright Act. And if such a design is of an article which is commercially produced, the copyright over the design under the Copyright Act will cease to exist when the article to which the design has been applied has been reproduced more than 50 times by an industrial process by the owner of the copyright. So this is a good way of establishing distinct protection for the same subject matter which may seem to overlap between two species of intellectual property law, namely design and copyright. When you read the requirements for design law, or as design law clarified, along with section 15(2) of the Copyright Act, we understand this distinction far more. The legislature's intent to allow a person who actually contributes with an aesthetic design as opposed to an artistic work under copyright law can be understood by comparing the kind of works and the impact or the effects or implications of protection extended to both species. So here is a table in this slide which explains this distinction. There are exclusive rights, that is, complete monopoly for large-scale production, wherein most countries also confer exclusive rights under design law, whereas in copyright law, it only protects against copying. Design needs to be registered. However, like I mentioned, copyright law is accorded automatically. Thus, there are no formalities of registration process which are mandatory. Design law requires originality and novelty, while copyright law's criteria for protection is originality alone, which means originating from the author, which is easier to fulfill as compared to the novelty bar of the design law. The duration of protection is 10 plus 5 years and can be extended further due to renewal. So a total of 15 years is a maximum term of protection for a design law. However, the duration of protection in case of copyright is much longer, which is life of the author plus 60 more years. And finally, a design can only be confined to the product that it has been registered upon. However, copyright law is not product specific. So the class of goods for which a particular design has been applied to is what protects and limits the scope of protection in design law, as opposed to what is protected in copyright law, which is not product specific. Let's understand what leads to actually infringement of a design right, and this is termed as design piracy, as mentioned in section 22 of the Act. Design piracy would mean an activity to publish or to have it published or expose for sale any article of the class in question on which either the design or any fraudulent or obvious imitation has been applied. To either apply or cause to apply the design that is registered to any class of goods covered by registration, the design or any imitation of it, and finally to import for the purpose of sale any article belonging to the class in which the design has been registered, and to which the design or fraudulent or obvious imitation thereof has been applied. So in short, Design piracy means an unauthorized copying of an aesthetic, appealing attribute of an article for commercial purposes. Section 22, Clause 2 stipulates a remedy against design piracy, and the remedy is a suit for damages, injunction, or for rendition of accounts, which is maintainable only when filed before an appropriate court, which may be a district court or a high court, depending upon the quantum of damages being claimed. What could be the defenses against a design piracy claim? Defenses to a suit of infringement would include functional requirements, as well as the article having no eye appeal. In order for infringement to be found, the court must determine whether the alleged infringing design article has the same shape or pattern and eliminate any claims for similarity. The remedies for a design infringement would include the remedies of which are civil in nature, which is an injunction, a suit for damages, delivering up of infringing articles, and criminal remedies would entail imprisonment or fine or even both. As mentioned, the Section 22 Clause 2 stipulates the remedy in the form of payment of money by the person who infringes a registered design. Further, in addition to payment of money, a suit for injunction restraining the infringement of registered design and for rendition of accounts, maintainable only when filed before an appropriate court, requires a sort of a strong remedy available for any person who indulges in creating original design works in India. To understand the overlap between copyright protection and design law, let's revisit the case of Escorts Construction Equipment Limited versus Action Construction Equipment Limited, 1999, PTC 36, Delhi. The Delhi High Court in this matter had the occasion to interpret this part of the definition as contained in the Designs Act of 1911. This case was concerning the alleged illegal copying of a design by the respondent of pick and carry hydraulic self-mobile cranes manufactured by the plaintiff. Though the case was not directly coming under the Designs Act, the court examined whether the said design was capable of registration under the Designs Act. And after examining the definition of the design under the Act, the court held that the design in question was incapable of registration. According to the court, the definition made it amply clear that the primary objective of the Act was to protect shape and not function or functional shape. And the expression design does not include a method or principle of construction of features or shape or configuration which are dictated solely by the function which the article to be made in that shape or configuration has to perform. So, rejecting the contention of the plaintiff, who claimed protection of certain specific parts of the crane, the court held the aforesaid parts of the crane are made in a particular shape so as to interrelate with others mechanically. And these parts of the crane are not made to appeal to the eye, but solely to make the crane work or function better. So, most of the key components or parts unseen in the crane for which they were required had only to pass the test of being able to perform their function, and they would be judged by performance and not by appearance. Consequently, the aforesaid key components or parts are incapable of being registered as designs, and therein we understand what can be an artistic work, but if found to be overlapping or having any functional attributes which are more than just mere appealing to the consumer's eye, they will be excluded from the protection of design law. So that is what this entire module contains. Let's revisit the learning points. We began by understanding the legislative history of design law, and the present Act of 2000 and the rules of 2001 apply is what we learnt. Thereon we understood the definition under section 2D and fragmented the definition to understand the meanings of what means or what is the essence of design protection. The two attributes which contain or as prerequisites for design protection are visual aspects, and this visual aspect needs to be necessarily applied to an article. And finally, we went on to separately study about the overlaps with design protection and protecting it from any functional design protection which is then falling into the subject matter of patent law and away from design law. We've also understood that landscaping architectural works, buildings do not constitute design protection. So industrial design, though requires industrial manufacture, all it essentially is trying to protect is an aesthetic value or an ornamentation to an applied article. And therein, we've learned that industrial design leads to rewarding a creative individual who ends up adding beauty to an article and therefore adding value to its adding commercial value to such article by appealing to the eye of a prospective consumer. I hope you enjoyed learning this and keep your thinking caps on. Thank you very much.